introduction. He was on our last panel and proved his expertise in the area of expert testimony and scientific evidence. And so Jeff Parker will take over as moderator. So Jeff, take it away.
Thanks, Donald. Yes, I need no further introduction. Although I should emphasize that of the 43 years I've been out of law school, 40 of them have been at the bar. So I've been at the bar the whole time, in addition to being a law faculty member. Now, this panel turns from sort of preaching at you, which I would take the last panel to be interpreted as, to now trying to understand what the courts are doing and how they're going about it. And for this, we have three speakers. The first is Justin Sevier, who's the Charles W. Ehrhardt Professor of Litigation at Florida State University College of Law. And he is going to speak most generally on this question based on some empirical work, right? Some empirical work that he's done. He's then followed by Cecilia Bidwell of Counsel to Shook, Hardy, and Bacon, LLP. And her background is as a practitioner with particular focus on medical expert testimony, right? And finally, we have my colleague, D. Bruce Johnsen, who's going to discuss the economics of all this, and with specific reference, I guess, to economists. Is that right, Bruce?
Yep.
Okay, so Justin.
All right, so I want to thank you all for joining us this afternoon. So I'm an associate professor of law at FSU. I'm also a behavioral researcher. My research typically focuses on jury decision-making, not judicial decision-making per se. But I think to answer this normative question, right, what is the role of the judge as gatekeeper? I submit to you that the research on sort of jury decision-making with respect to scientific evidence is a critical consideration with respect to how we would perceive the role of judges in admitting expertise into evidence. So from an empirical perspective, I think that examining this normative question can be informed by an understanding of what we know, at least right now, about how judges actually perform the gatekeeping task. So I'm going to start by relaying to you some of the major findings from the behavioral science literature, illustrating how well judges appear to understand the different methods of evaluating expert evidence, and how they tend to apply those different aspects of the gatekeeping role. So based on that data, I'll discuss some of what I think are the more promising sort of evidence-based gatekeeping proposals that are out there, with an eye toward recommending what you might be able to do when you get back to your courtrooms this week after the conference. So by way of preview, I'll raise for consideration what was raised in one of the articles for this particular panel, which is elevating in your sort of gatekeeping toolkit this concept of double-blind peer review, which is relatively underused, while also regulating kind of the effects of your admissibility decisions through your Federal Rule of Evidence 611 and state law counterparts, sort of control powers in terms of how you run your courtroom. So let me just say a little something about juries in scientific evidence, because I think it highlights the stakes of the gatekeeping function well. So there's actually a lot of research on jury decision-making, and a lot of it actually is quite positive. Says that a lot of evidence that we typically keep from juries, propensity evidence, inadmissible hearsay, they're actually quite good and quite thoughtful in terms of how they deal with that type of evidence. Unfortunately, it's not the same story with respect to scientific evidence. So there's a vast body of research on this that suggests that scientific evidence that requires numeracy skills, juries tend to flounder with. They tend to rely on sort of heuristic, superficial processing as that expertise gets more complicated. And they can be fooled by sort of the form of the evidence, giving too much weight to sort of unrepresentative anecdotes at the expense of kind of dry, uninteresting statistics. But I think the most important finding in the jury literature for you was a finding by Michael Sachs called the Gatekeeper effect, sort of fittingly titled, right? So he did this elegant experiment. I won't say too much about it, but essentially he created this trial simulation where he had a judge admit evidence and he had jurors, mock jurors, sort of evaluate it, give their takes on it. Then he did the same thing with another group, but not in the jury context, just gave them the information and asked them, how persuasive do you find this evidence? What do you think about it? And what he found was sort of shocking. Exactly the same evidence, to the letter, word for word, got a credibility bounce by virtue of having been admitted by the judge in the trial context. That is, if jurors had seen this in a trial context, they rated that evidence, that same evidence, as more persuasive and more compelling than if they were not in the trial context when they got that. So what Professor Sachs says is, okay, so what's happening here is the judicial gatekeeper kind of imbues the evidence with a halo, right, with an aura, potentially, at least at the outset, of sort of additional credibility that it doesn't seem to possess on its own. So a mistake in judicial gatekeeping, right, letting in already bad evidence, the worry here is that it's likely to be compounded downstream, right, once it gets to the jury that then has to find facts based on that expertise. So he says that, the upshot here is then the burden on judges to make the correct gatekeeping decision becomes all the much greater. Right? So with that in mind, that brings us to the main question. So how well do judges appear to perform the gatekeeping task? At least what do we know in the behavioral science literature? So sort of two things here. How well do they understand the different gatekeeping aspects, and how well do they apply them? So the general gist is that all factors are not created equal, right? So first, the good news. So this was a study surveying 400 state and federal judges, so some Frye, some Daubert, and they were asked about different aspects of the gatekeeping, sort of the gatekeeping formula, right? Things like peer review, general acceptance, et cetera. So the good news is that with respect to the peer review factor and general acceptance, you had understanding, they coded their responses of upwards of 70 and 80% for those two factors. It seemed that judges had a clear understanding of what peer review was and its potential for what it can say about evidential reliability. And perhaps not surprisingly, same thing with general acceptance, since that was under sort of the old guard before Daubert. It was, however, a very different story when we get to things like validity, falsifiability, error rates. So here, almost everything was under 10% in terms of sort of full understanding, being able to articulate things like hypothesis testing, being able to talk about false positives and false negatives, right? So in addition to that, in these sort of simulation experiments, they came up to the same conclusion. They had judges look at, for example, these trial simulations that were based on real cases. They gave them sort of the real expert evidence, except they would manipulate things about the study, the underlying study that formed the basis of the expert's opinion, and tried to see if judges were sensitive to those. And all the manipulations were always for the worse, like potentially invalidating the study. And so some good news here is that judges who had some scientific training, including the type of training you are doing here over the next few days, they were actually fairly sensitive to these potential problems in the underlying studies. But that was not true with judges who had no background in science. So there were no sort of difference in their admissibility rates versus sort of a good study versus a bad study that formed the basis of the expert opinion. All right, so if that's right, if that's where we're at with respect to the factors, and not all equal, but we can put them into two different groups, right? So what do we do with that? So there's sort of two camps here, kind of the go big camp and the what I think of as sort of the practical camp. So the go big camp, so they have a bunch of proposals out there. Probably the most well-known is the using Federal Rule 706 and state law counterparts with respect to neutral experts. And I think more controversially, potentially the creation of specialized science courts, right, akin to the Federal Circuit or the Delaware Courts of Chancery for business. So these are thoughtful and important propositions, but I think we need to recognize some real sort of reservations that many different groups will have with those, right? They're lofty, which means they are expensive. They are, I expect some of them might engender sort of political opposition. So here I'm thinking about the dust-up over the science court in the 1970s. That became political very quickly. I also think some of these solutions might lead to sort of apolitical backlash to the extent you create, for example, courts that have these more kind of inquisitorial administrative features to them. There's a concern that maybe decisions from these courts might be perceived as less legitimate because they don't look like the adversary system that we're sort of used to. But what about sort of the more practical short-term solution? So this is where I think Professor David Faigman's article that was assigned for this panel is particularly interesting. His proposal is very bold, probably bolder than I would go here, where he suggests maybe all expertise be exposed to this concept of peer review. I would say this, so peer review tends to be, as an empirical matter, it is sort of underused, seems to be underused in terms of the different factors. And so there might be some value to it to the extent, right, that when we have expertise, what we worry about, picture like a distribution. What you worry about is you have sort of plaintiff's expert at one pole, defendant's expert at the other pole, where the bulk of sort of what you might think of as the reasonable scientific view of things is kind of in the middle of that curve. So one thing we worry about is that the adversary system incentivizes parties to go to the polls and not reach toward the middle. So one great thing about the peer review concept is that to the extent you can get your ideas passed through a rigorous and well-working peer review idea, it's one of the more adept factors, I think, that can push these experts potentially from the polls kind of more into the middle. So one thing we might do then with respect to this gatekeeping function is actually lean into the evaluative strengths, right? Like peer-reviewed general acceptance. Well, not necessarily ignoring things like testability, validity, and error rates, but to the extent, until better education can happen, maybe it is okay to sort of lean, at least to some degree, away from them. Why might I say that? So one thing we might say about peer review, right? If it's double-blind and it works as it should, someone who passes peer review, right, they presumably demonstrate to those who are in the best position to evaluate it, the testability, validity, and acceptability of error rates of their technique. That is, it actually speaks to those other things that the court might not be so good on its own of evaluating. So I also think this sort of relying on peer review might help us with respect to, as they talked about in the last panel, sort of these techniques that have been grandfathered in, even under Daubert. Particularly, I'm thinking of non-DNA forensic evidence, where, as they said last time, sort of acceptability in the courts has somehow become the standard. Maybe if you have a rigorous sort of functioning peer review, maybe it allows more careful and exacting scrutiny of those things. So one thing you might say, though, is like, okay, so if you do this, maybe this results in more liberal admission of scientific evidence. Some people might say, well, that's arguably what the court had in mind in Daubert. Some people disagree about that. But to the extent there are these downstream effects, right? You let in more, there's a worry that the jury is going to have some problems with it. There are things you can do, right? So one part of your gatekeeping role would be sort of remembering that there are downstream effects and using your powers under the federal rule would be 611A, right? So to order the evidence, do things with the trial in a way that leads to accuracy and leads to justice. So you could do some procedural reforms aimed at increasing juror understanding, so that would be allowing note-taking, allowing the questioning of experts, allowing, at least to some degree, jurors to talk to each other before you get to deliberation, to the extent that might lead to more avenues of questions for those experts. You might even, perhaps more controversially, reorder certain aspects of the trial. One idea floated around the empirical literature is, rather than kind of wait for different experts, throughout the trial, once one case in chief goes, then the next case goes, and then wait for rebuttal, instead just put them back to back so that the jury is dealing with them all at the same time. All right, so I'm just about out of time, so I'll just say, sort of wrapping up here, the answer to at least my take on the normative question here. This is a difficult task, all right? And I think the empirical research says it's a pivotal one, particularly because of those downstream effects. So I recommend, with the sort of ideas that I've just expressed, non-passivity is the way to go. But I don't know that being non-passive means aggressive. These kind of incremental changes might be the more fruitful avenue, at least here in the short term. Thanks.
Thank you. Next, Cecilia.
Yes, good afternoon, everyone. Unlike my esteemed fellow panelists, I am not a legal scholar or a academic. I have not darkened the doorway of a law school since the day I graduated, but I am a legal practitioner, and my job for the last 10 years has been entirely focused on recruiting, developing, and preparing expert witnesses, particularly medical witnesses, for deposition, for trial, and assisting trial counsel with crossing the other side's expert witnesses at trial. I've deposed, I don't know how many different expert witnesses in the last 10 years, but it's been a lot. So that's kind of really what I work with every day. And I've been a part of, I think, around 20 different civil jury trials, mostly in state court here in Florida, but a couple in federal court. And those trials typically have been anywhere from 3 to 6 weeks, and all of them have involved roughly between 2 to 6 expert witnesses on either side. So I'm very familiar with the idea of the judge as a gatekeeper, or sometimes of not being as much of a gatekeeper as we would like. So I have some things I want to ideas I want to share with you from a practitioner's point of view. And my colleague, Mr. Sheehan, who spoke to you on the last panel, actually touched on a few of these. And I just want to say up front, unlike him, I do not have a degree in epidemiology. And in fact, I don't have any background in science at all. But what I think that enables me to do is to look at scientific and medical experts and expertise in a way that's probably more similar to a lot of you. Some of you may have scientific backgrounds, but if you're judges, you were probably lawyers before. And if you were lawyers, you likely didn't have that much of a science background before you went to law school. So I think I'm positioned in a way to sort of see how we can simplify things and help judges recognize the key issues and be effective gatekeepers in terms of what gets to the jury. And because most of what I do is working with medical experts, I want to talk a little bit about a framework that I think is helpful in those issues. And also because as long as we have plaintiff's attorneys, we're going to be seeing personal injury cases, we're going to be seeing wrongful death cases. And all of those cases are going to involve medical issues. So where is the challenge with medical experts? And one of the first challenges is that medical specialty doesn't exist in a silo. And I'm going to use the example of someone who's a pulmonologist, a lung doctor. So they see patients with all kinds of lung conditions, but they're going to see patients, for example, who have lung tumors, lung cancers. So they need to know a little bit about, more than a little bit, in fact, about oncology. They're going to look at chest x-rays, CT scans as part of their everyday practice. They need to see where the tumor is in their lung cancer patient. They're going to see reports coming back from the pathologist that tells them what the cell type is. So they are going to need to know a little bit about pathology. So there we have a pulmonologist who has some expertise in oncology, a little bit of expertise, maybe a lot of expertise, depending on what it is exactly that they do. They need to know a bit about radiology. They need to know about pathology. But are they an expert in all of those branches? Can they testify about all of those different specialties? And that is, I think, where that question becomes tricky for judges. And traditionally, in almost all states, courts have been very liberal and permissive in terms of who qualifies as an expert. And there's quite a lot of case law that essentially says, if you've got a medical degree, you're not bound to only testify in your specialty. You can testify about medicine, and that it goes to the weight of the evidence in terms of how specialized you are. But there obviously have to be some outer limits to that. So one of the things, the frameworks that I think is helpful when evaluating how far a medical expert can go is to look at it not as a specialty in a silo, and whether the person has expertise in this different silo, but to treat specialty and expertise more as a tree trunk. So if we take our example of our pulmonologist, who's he's a specialist in lung diseases, or she is a specialist in lung diseases, and then we do have these branches that come out of that tree trunk. Oncology is a branch, pathology is a branch, radiology is a branch, cardiology might be a branch. And in that pulmonologist's actual practice, they need to know those things to treat their patients, and that's a necessary part of medicine. But how far out on the branch can they go when they testify? And at what point, moving out along that branch, does that limb start to break? I mean, it's literally called going out on a limb for a reason. So with that kind of image in mind, that is where I think judges can just take a very simple framework and ask the question, is the proffered testimony, is this within this expert's specialty? Is it in their tree trunk? And if the answer is no, then the next question has to be, well, how far along out on the branch is it of the other specialty? And it may be that it's not that far out there. For example, if we go back to our example of our pulmonologist, maybe what they're trying to testify to, or they want to do, is just show the jury a picture of a chest X-ray with a huge lung mass, something you could see on Google Images if you wanted. That's not super controversial. But are they trying to do something that they could not do in their own practice? And that's really where I think the question lies. If they couldn't do it in their own practice, should they be able to do it in the courtroom? So if we talk about our pulmonologist who, can show a chest X-ray with a huge lung mass that anyone can see on it, that's probably fine. But if this pulmonologist couldn't interpret a PET scan or a CT scan for a patient without deferring to the expertise of a radiologist, should they be able to do that in the courtroom? So that really is the second question, is how far out in the branch are they going? And then there's a third sort of related question, which is, what are they relying on? In what case-specific materials are they relying on in offering this opinion that's getting a little bit outside of their specialty? One of the issues that we see in medicine is, and that shows up in medical records, is this issue of medical billing and insurance, where diagnoses will be noted in the records, sometimes because that's the only way to get paid for it, or because the patient might need to see a specialist and they need a diagnosis noted in the medical records. Now, there's nothing, I'm not saying that there's anything wrong with doing that. There is nothing wrong with doing that in medicine, and medical records are generally admissible under, the business records exception. But when you have an expert from a different specialty who starts to opine about diagnoses that they could not make for a patient, and they're basing that on information that's in documents or medical records, where they are unable to explain, or anyone is unable to explain what the methodology was that went into that particular diagnosis, then we're really starting to reach the outer limits or parameters of really what is good expertise. It may still be, and this is within what is still good science. I mean, medicine is generally good science, but it's more a question of, should this all come in as the expert too far out on a limb? So I think those are three key questions that judges can ask when faced with medical experts who are going out literally on a limb. How are they outside of their specialty? First question. And then really, I almost think of it as a burden shift of how far out in the branch then are they going? And that's going to be a very individualized inquiry depending on that expert's particular practice. Somebody who lives in coal mining country is going to have a lot of expertise on things to do with black lung, for example, or it can vary from place to place, from practice to practice. But I think at that point there should be a burden shift where the party proffering the expert needs to show they have a level of expertise where they should be talking about this. And then probably some of you may be wondering, well, why does this issue come up to start with, that experts are so willing to go, in some cases, outside of their expertise? And the obvious answer is usually that it's a cost-saving measure for the party. Sometimes if you have 4 or 5 different medical issues that are implicated by, whether it's a drug case or some other kind of medical issue, it's easier, it's cheaper sometimes to have one expert address everything, but that doesn't make it appropriate. And what we sometimes see when this comes before the court on, a Daubert or a Frye motion, or, it's being challenged by the other party, is that the party whose expert it is will essentially say, Judge, if you preclude my expert from testifying on this, you're gutting my case. And I can tell you from my experience in the last 10 years, it is amazing how often that expression works. Judges are not looking to gut people's cases, but the standard needs to be something other than, the standard needs to be on what the evidence is and on what is good science and what is the right science and medicine to go in front of the jury, not on whether the attorneys didn't do their job properly or weren't prepared enough to find experts, basically, to cover the different specialties. And then finally, I just wanted to follow up on one issue that, just to segue into what Justin said about peer review. And that is that peer review, it's an interesting concept to read about in the reading materials today. But judges already have the toolbox to make these decisions, and those tools as well come from the attorneys who are in front of you. It's their job to educate you and explain to you pre-trial why their expert is qualified, why the science is good, and why this should go to the jury. And if they can't do that, then it probably, if you can't understand or you are unable to be assured that the science is good, then that probably shouldn't go to the jury. If the lawyers can't explain well enough through their expert, then that raises questions right there without the influence of an outside peer review panel. And I realize the peer review panel is just sort of an academic discussion at this point, but that does, to me, open up the question of outside influences. I think that also would have a greatly chilling effect on the ability to recruit and retain qualified experts for, so we say, more controversial parties. For example, pharmaceutical companies are kind of having a bit of a moment right now with the COVID vaccine, and everybody likes Pfizer, but that's not always the case. And if you were to have experts who know that they will then be put before a peer review board within people of their own faculty, I think that would have a very chilling effect on the ability to recruit good experts and put good science before the jury. So that was my final sort of comment. Jurors tend to take their jobs very seriously. As in one of the reading materials for this panel discussion, I did agree with a lot of the conclusions that was in that jurors really do a good job. Most of them don't have scientific backgrounds, but they do take their jobs very seriously. They will consider all the evidence, but it is key that the judge act as a gatekeeper to make sure that what they end up hearing in the end is what they should hear and not just the product of somebody who's an expert on everything.
Thank you, Cecilia. Before moving to our next speaker, I wanted to remind everybody that audience questions are welcomed and encouraged. So everybody knows how to submit them, right? And they should show up here if there are any, because I don't see any so far. So if there's some technical issue, please address. In the meantime, we're going to move on to my colleague, Bruce Johnsen.
All right, thanks, Jeff. It was very interesting. I was quite not surprised, but excited when Daubert was first decided. And I really thought it would have the teeth that it ultimately has had. One of my colleagues insisted, though, it's just expert testimony, it's just come down to a battle of credentials. If you get somebody from Harvard with 2 PhDs, that's that. It's going to be admitted. And I disagreed. And it wasn't long after that a very famous economist, Robert Lucas, who had won a Nobel Prize in economics, he went into court to testify in an antitrust case for the plaintiffs. And he was basically immediately shown the door. Antitrust is not really within the realm of what Robert Lucas won his Nobel Prize for. He won his Nobel Prize for something called rational expectations. That is, in markets, the markets kind of anticipate the future, not perfectly, but in an unbiased way, and so on and so forth. And, he was just way out on a limb. And that was a real quick lesson, at least for the world of economists. Let me say also quickly something about peer review. You heard Gary Marchant today, and that probably, I hope it scared you somewhat about kind of the power of the test of peer review. There's another thing about peer review that has been troublesome, but I think is getting less so, at least in economics. And that is, as Jim Treffel used to say, you submit your paper to a journal and it's got empirical findings. They don't ask for your data and check your results. They don't even do it on a kind of a random basis, right? The journal just believes what you tell them. And so there's obviously the potential for abuse there. What is interesting, though, that again, at least in the world of economics, some professors around the country, one at Berkeley who teaches the graduate price theory course, which is microeconomics, one of the things he has his students do is they have to identify an article, an empirical paper in economics that's been published, and they have to get the data, and they have to try and replicate the results of the author. And there have been some real doozies there. Stephen Levitt, you've all heard the book Freakonomics, right? One of his papers, I don't think it was a chapter or anything in his book, but one of his empirical papers, the grad student just couldn't reproduce the results. And initially the faculty member at Berkeley was kind of an unpopular guy because so people they cling to their theories. Sometimes they even cheat. So it's good to see that kind of development. What I want to really do is talk about just some branches of economic theory and how they would fare under a Daubert standard. What's the kind of core of what economists do that could be or is considered generally reliable. Just take market prices. You don't really need an economist to say what the price of something is. Let's say you smash my Corvette. It's a 1967 Corvette. We can go into the marketplace and find comparable Corvettes and be pretty sure that the price we see, or some average of the price we see, is a reliable indicator of what I lost, or the value of what I lost. So we wouldn't have an expert testify on what the market price is. That's a fact, right? It's, price of IBM stock is listed in the Wall Street Journal, or Corvettes, or whatever you happen to have. But there might be some theoretical proposition that the expert relies on and uses market prices. And economists didn't invent this notion that, the price that's generated in an arm's length transaction is a reliable indicator of value. Might even have been kind of started by accountants, right? Because accountants need that. You can't just estimate the price. You got to have some kind of objective basis for ascribing a price to something. So the price between willing buyer and willing seller in an arm's length transaction. What about, say, in some cases you come up with a question of diminution in market value or market price. That's, certainly tried and true and consistent with economic models and so on and so forth. The question is, how do you get the estimate of the diminution in value? And lately, in the last, recently, there have been a number of cases in which the expert's theory of diminution in value has been rejected. And from what I have been reading, it's been kind of some of those little close-knit associations of people who proclaim themselves to be experts and publish in their own journals that Gary Marchant talked about. Also, in some cases, we've had aluminum phosphide litigation in which, liability for price fixing had been established in a criminal case, and then the question, what was damages for the plaintiff? And the plaintiff's expert, did not use the before and after test. What was the price of aluminum phosphide before the alleged conspiracy to fix prices and after the alleged conspiracy to fix prices, but I think took only the before, because it appears as though that was cherry picking and that gave him an advantageous answer, and that was Dalberted right out of existence. What about hedonic damages? Has anybody ever had somebody come before them wanting to provide evidence of hedonic damages? At least, we might get into the lost value of the enjoyment of life or something along that. What about the lost value of the enjoyment of my Corvette? I don't have a Corvette, but if I did, I'm thinking of the Sedmak versus Charlie Chevrolet case, if you ever remember that one. I'm thinking of the amount, surely what I paid for the car was the market price. And generally courts are perfectly happy to use the market price as a good, reliable indicator of value. But that's only at the margin, right? The market price is a good indicator of value for the marginal buyer and the marginal seller. That is, the buyer, of all those buyers who succeed in getting the good, the one who is willing to pay the least, but just pay enough just to get it. And of all the sellers who are willing to sell, the one who had to be paid the most, but was just barely willing to provide it. That's what you get with market prices. But what about all those buyers, who value the Corvette a lot more? They would have been willing to pay a lot more than $30,000 for the Corvette. And so, economic theory, basically, it understands that there's this thing called consumer surplus, or at least our theory is consistent with something called consumer surplus. And hedonic damages is, at least in part, or under certain circumstances, it's trying to aim to figure out what that extra is and provide compensation for, say, consumer surplus. And, the problem is that it's there in our theory, and our theory works well to make predictions about how does price change when we impose a tax, and how does the number of units transacted change when we propose a tax. But we don't have the ability to really accurately measure things that are not happening, as economists say, at the margin, right? And that's what's reflected in market price. So although it is completely legitimate, theoretically legitimate, to think about hedonic damages, there's a huge measurement problem. And thus far, my search showed that I couldn't find a case in which hedonic damages were not excluded. Then that brings us to two kind of emerging or emergent subfields of economics theory, or maybe not, but we have game theory. You've all heard of game theory, the classic game theory example of kind of game theory. Game theory is about how rivals react to one another, right? And strategies they may have. And so in economics, the old line assumption is that rivals ignore one another's behavior. If I'm setting gasoline prices at my station, I don't even pay attention to what you're doing down the street, or what Joe's doing further down, or Sally's doing further down. I just assume that you're not going to react to me, and I don't pay any attention to you. And that's clearly unrealistic, but it's a good model for predicting. Game theory is all about those strategic interactions. And the problem with game theory is that you show me some behavior, those two gas stations raised their price together. Oh my God, that's consistent with a model in which, such and such is the game, and this and that is the strategy of the players, and that strategy is anti-competitive. Okay? Well, okay, so what? Right? The strategy is also consistent with competition, right? Two firms that are actively competing might engage in exactly the same behavior. One raises its price, the other raises its price. One lowers its price, the other lowers its price. So the problem with game theory is coming up with a theory about which set of assumptions to make about how rivals react to one another. I'm not saying you should never admit game theoretic testimony, or nobody should ever admit game theoretic testimony, but that's kind of the Achilles heel. And the same is true, well, not exactly the same is true of behavioral economics. I'm a doubter in behavioral economics. I don't even know that it's economics. It seems to me it's a series of observations, gotcha moments in which, well, economists can't explain that. Look, and it's, those things are true. Confirmation bias, availability bias, all sorts of biases people have. One thing that's interesting, the experimental economists have worked with that, and what they say is these behavioral anomalies can be made to go away in experimental labs, right? So you adjust things slightly, and all of a sudden what people thought was this consistent anomaly, it shrinks. Or as Harold Demsetz used to say, it's one thing to put two undergraduate students, in a lab where there's $10 at stake, and quite another to talk about somebody who is, an active market participant and putting their money where their mouths are on a daily basis. Like, think of the specialists on the New York Stock Exchange or something along those lines. And so you can make those behavioral anomalies go away pretty quickly is A. But again, there's a problem, as with game theory. How do you select which behavioral anomaly is relevant in any given setting? I'm not saying it can't be done, but it takes some legwork by the expert to make that case. And you want to be careful that that expert is consistently applying their theory.
Thanks, Bruce.
Sure.
Well, we have one question so far. Let me again encourage you to submit more questions. I believe this is directed to Cecilia, because the question is, regarding physicians and an actual treating physician, in the context of testifying outside their wheelhouse, is that not a case-by-case basis?
This is such a great question, and this comes up all the time. So I think it does depend on the state you're in and what the rules are. In Florida, we do a bit more of a hybrid approach, where testifying physicians kind of are sort of hybrid experts. But if we generally, the rule should be, a treating physician can testify to their care and treatment. Now, is part of care and treatment also obviously knowledge of the literature, their own experience and training comes into it as well. So again, it's hard to know, there isn't sort of a clear delineation of that. But I think a good way to approach the problem or issue of a treating physician goes back to that. What would they be able to do within their own practice? Of course, they're going to have some knowledge of other parts of that patient's treatment and work in a sort of interdisciplinary team, but it's really a kind of a spectrum of how far out can you go. So I think the same analysis tends to, it's not the same analysis because they are treating the patient, but in medicine, there is a point where their expertise also, depending on what the injury is as well, but there can be a point where their expertise stops and it's the domain of another doctor. So generally the rule should be care and treatment, but within that is, of course, the doctor's background, their education, their experience, and that is necessarily going to include some knowledge of other specialties as well. So I hope that answered the question, but it's a fluid and moving one. And of course, medicine is an always evolving field as we want it to be. So what might be right out there for a pulmonologist today might not be right out there in 5 years.
Thank you. If there are no more questions from the audience, let me call upon the panel members if they want to ask each other questions.
I got one for Justin. I'm not sure I heard you say this, but you seem to suggest that things like falsifiability and hypothesis testing are very difficult for juries to understand, and they don't understand them well. And did you then say that then the judge should lean away from emphasizing those things? And I think that's a dangerous thing, because we would want our jurists to get better over time and have that embedded in the law, that that's the bar. And
Yeah, I think I took that to what I was envisioning was more, if I forget exactly how I said it, but it sort of I would say not lean away from it necessarily, but to the extent you can sort of supplement. So what I'm picturing are sort of while we're doing the long-term things, right? Like educating through symposia like this or what have you. As we're getting a bench that is getting more and more sophisticated with respect to understanding these concepts of validity and falsifiability. What can we sort of additionally do in the meantime as we get to that goal, which I think is absolutely an important goal. Symposia like this I think are absolutely critical to this goal. And so what I was envisioning more was, we don't stop doing that, but maybe we lean more on things. Like we can talk specifically about peer review, and I don't quite take the view of Professor Fagman in the readings. I don't know that I go that far, but I do think it can be sort of a useful supplement as the judge is doing the other steps of Daubert to then see if what the expertise looks like as a matter of peer review. Are there a lot of peer-reviewed publications? In which case, if it is working properly, and you've raised some very real issues about peer review that we can talk about, will it also speak to those same things? A lot of the things that the judge is required to do under Daubert, those are things that reviewers are actively doing, at least in peer review in psychology and the empirical sciences. So maybe in some way they kind of dovetail with each other. So I don't mean to suggest that we should sort of back away from that necessarily. But it does seem to be, as an empirical matter, there are some, like Professor Shari Diamond at Northwestern has sort of looked at how often these different factors get used, how many words judges tend to use when they talk about these factors, and peer review does seem to be the sort of neglected factor of all of them. So I would say don't necessarily lean away from it, and I don't mean to suggest that, but certainly supplement, and I think peer review is actually a good way to do that.
I had a similar concern I wanted to raise, because I do address this in my notes on from the previous panel, so that you can look at those if you want. But I, like a lot of other experts, but there's a big difference of opinion, really discourage the use of Rule 706 or science courts or expert clerks because, among other things, it creates this problem of too many cooks in the kitchen. And if you take in a third expert, because you can't fire the party's experts, at least most courts think that's true, the third expert, it really isn't going to improve your estimate. And indeed, there's some theory work by one of my colleagues, Bruce Kobayashi, with Luke Frobe, I don't know if you're familiar with that, that questions under a economics modeling point of view, not an empirical study, questions whether or not this neutral draw improves your decision making, even if you take a very simplified model of what it is you're trying to find out.
Yeah, so I think that's right. That's why I sort of raised those kind of systemic big picture things and then said, well, in the meantime, maybe we should focus on these other things. So I think that's right as a matter of sort of decisional accuracy. I think what I would add to that, a very real concern, I think many judges tend to have this concern as well, at least some of the empirical research suggests that in addition to there maybe not being as much value added on the decisional accuracy sort of side of things with Rule 706 experts. There's potential issue of sort of perceived procedural justice and legitimacy. So a lot of the work I tend to do on the law and psychology side is looking at legal rules, looking at procedural or looking at processes and trying to figure out what types of processes do people regard as fair versus unfair. And then to the extent they view these processes as fair or unfair, how legitimate do they view these processes? How well do they think that they do justice and that they are the right strategy? And what I've sort of found again and again is you get this trade-off between sort of these procedures that are meant to increase decision accuracy. So that might be something like Rule 706. So you can think of like the inquisitorial systems out in Europe, right? They kind of focus on decisional accuracy, but at a cost, right? At a cost that the litigants don't feel like they have as much say in the procedures, right?
Yeah, but also with the result that they get less.
That they get less.
Well, that I think that's what was shown by this experimental work that Block and I did. They actually do worse.
Wait, when you say do worse, you mean
they make bigger mistakes.
Oh, you mean on the decisional accuracy? They actually get to worse decisions.
The inquisitorial system makes big mistakes. The greatest virtue of the adversarial system, and this is we sort of were stimulated in this by this de Watrepont and Tirole paper on what's the difference, And their point is advocates tend to increase a split the difference type decision. And we had some data from our experiments that we did in the 90s, and we sort of tested the data against that hypothesis, and we certainly failed to reject that hypothesis.
Yeah, it's interesting because they, like the sort of theory.
Sorry, we may be getting too long.
Yeah, I'll just say like we can talk about this offline. And I basically agree with you on that point. But like the bigger point on Rule 706 is to the extent the parties then get less say over at least what they proffer up to the courts, whether the courts reject them or not. That's a substantive question. If people start to see those procedures as not fair, even if they are designed to get at sort of more accurate opinions, you get this counterintuitive effect, which is people are sort of less likely to legitimize those courts that make decisions that way.
If the extra draw, if the draws all then become even noisier than they were before, right?
Yeah, I think that's right.
In adversarial draws, you can be pretty sure that one side picks the draw that's most favorable to it, and the other most favorable to it. And so then, if everything depends on the quote-unquote neutral draw, then you're worried about how noisy that might be.
I think that's right.
So you can't just average out the three, and that's the problem with these. But you're saying that they might be perceived to be.
In addition to that, in addition to sort of the objective issue you raised, there's a perceptual issue too.
Okay, we have no more questions from the audience, and I have no more questions. Anyone else? Oh no, we have one. If the admission of expert testimony is based on education, training, and experience, how much study an expert on the limb need engage in to become qualified? I mean a human limb?
Right.
Is that what it
out
means?
on a limb. Well, I mean that is the big question.
On the limb, you mean on the edge of their expertise? Yeah.
I mean that's the question for judges because there isn't really there isn't a standard out there, and it varies from court. It's going to vary from court to court. It's going to vary. So I think it's just a highly individualized, case-specific analysis. But certainly what we've seen is that the trend, and I mean, no disrespect to any of my Florida judges, none of whom I have appeared in front of who were at this conference. So, but what we've seen is that the standard has become really so liberal in terms of if this person's got a medical degree, essentially they can testify to anything maybe not ridiculous things like if they probably can't, a GP probably can't, testify about laser neurosurgery, but what we tend to see is that if they've touched on one specialty, they can pretty much testify about just about anything that's in the medical records. The exceptions, of course, are in some cases. Some states have rules on medical malpractice. You need to be in that specialty. But that question is exactly the question. How far out on the limb can they go? And it's that specific question that the judge has to be the gatekeeper on. And I think it just requires...
Mind if I follow up on that?
Sure.
Because I thought what I heard you say before was, if it's within the normal practice of, let's say, a GP to know this much about, let's say, neurosurgery or some other thing that they're not themselves expert in, that's the constraint, isn't it? I thought you said that, but I may have misheard you. No, it's based on their day-to-day practice. They have to know enough to know when to refer somebody to a neurosurgeon, let's say.
I think that's one thing that can be a consideration. I don't think we can necessarily make the exact translation from medicine so clearly to law, but I think that delineation, that's where that should be the flag for the judge to. I don't think I'm not sort of advocating for like a hard and fast rule that, well, if they couldn't do this, they shouldn't. I guess I did actually say that if they couldn't treat this person and whatever, they shouldn't probably. It doesn't mean they can't testify. It also depends on the content of the testimony. Are they just testifying about there is this issue and we understand as a general matter of medicine it could be this?
Right. Well, the reason I follow this up because there is an analogy here to a case that I discussed, and we haven't had a chance to talk about this because it has more to do with expert practice than admissibility, but I'm referring now to the Sanchez case.
Sanchez, and I read it, and I was actually going to talk about it, but I didn't think I had time.
Yeah, well, but there, remember, the context is the California STEP Act, which is like a anti-street gang organized teenage crime, anti-organized teenage crime thing, nothing to do with medicine. But in the context of it, the prosecution calls as their expert a specialist detective, and the detective wants to talk about these tracking reports that his colleagues have put in on the local gang leaders, and the court rules that he can't because they're hearsay and they're not legitimately relied upon by the expert. So they sort of draw a line on the limit of Rule 703 that I think is very, very interesting and much better done than the U.S. Supreme Court, by the way, who sort of caved on that whole issue in Williams versus Illinois. So this was a very interesting, and they give the example of the doctor who is allowed to rely on what's in his medical books, but he can't rely on the
case-specific.
The case-specific facts.
And that is, and sort of that is one of the issues we have. But I'm not advocating for like a hard and fast rule on that, certainly, because well,
of course, it had to be in Sanchez because it was also a confrontation case, and so
that's dealing with it. Obviously, it's a criminal law case, but there is. And doctors do rely on the medical records of other doctors in their practice, but it's one of those factors where I think you can look at that. You need to look at that particular what is being relied on in a more of a case-specific basis, rather than making. I wouldn't really advocate for a general rule, but I think there's a step-by-step analysis that you can make where maybe there's some burden shifting for the party whose expert it is to show this, yes, I'm out on a bit of a limb, but here's why I should be able to talk about it. And here's what I relied on, and this is why I know it's reliable, or this is why this particular thing is reliable, or this is why, me being out on a limb here, I actually do have this expertise. But I think it's more a question of seeing these cases and recognizing where there's a question mark, or where there's maybe a bit of a burden shift to needing to show that this expert should be able to be out on the limb here, because maybe using the tree trunk analogy, maybe it's a pretty strong branch they're on because that particular expert does have more expertise or does have very reliable data to rely on. So.
Anything further from anybody? I know I'm going to be criticized for this, but I'll take it upon myself, unless there is objection. Hearing none.
You have to form it as a question, not a...
Well, it wasn't in the form of a question, but I heard no such outcry. And so I'll take, in the absence of the program director, I hereby declare our proceedings closed for the day. 13 minutes early.
The beach calls.
And thanks for the panel. Yeah.